of dissolution in this case was entered on April 30, 2025. A few months later, on September 10th, 2025, Mr. Canfield filed his original motion for entry of a qualified domestic relation order, or the qualified domestic relations orders, and for sanctions. The petition for sanctions then ended up being continued several times. We had court appearances, on September 24th, it was continued. On October 29th, continued. On December 3rd, continued. And I should say there have been several occasions where Mr. Canfield is represented, for example, that he had presented draft quadros to the plan administrator and was waiting to hear back from them. But an underlying theme was that Mr. Ainsworth, on behalf of Mr. Gibbs, had failed to agree to a quadro to even send to the administrator of that plan. On February 4th, the parties appeared and indicated that his client was not in agreement with the quadro because it referenced it had a surviving spouse provision that bothered him. And as far as I can tell from the record, that was the only explanation ever given to the court as for the delay, which is coming on now, a marital settlement agreement that was entered 10 months ago. So, Mr. Canfield, it's your motion. You go first.
Judge, did you get my pretrial memo?
I did.
Okay.
It doesn't say much other than he didn't, and we should impose sanctions.
Right. The marital settlement agreement provides specifically that wife is awarded any survival benefits as may be available. That was the order of the court. All we're asking for is for the quadro to follow the order of the court, which was an agreement at that time. It was not a contested hearing. It was an agreed prove-up. So at that point, Mr. Gibbs had agreed to the terms contained. He then later changes his mind. I don't think he can do that. It's done. The court order has been entered, and all I'm doing is trying to enter a quadro in conformance with the order of the court.
Now, I'm going to go back to this. The marital settlement agreement was approved and incorporated into the judgment of dissolution as an order of the court, as part of the judgment of dissolution, which is an order of the court. So I'll agree with you on that.
All right, guys, this case wastes no time pulling you straight into the legal fire. Within seconds, we hear about a finalized dissolution, and then, boom, a motion for sanctions enters the picture. That alone signals trouble brewing beneath the surface. The filing of a qualified domestic relations order might sound technical, but paired with sanctions, it hints at non-compliance or conflict. This opening clip is sharp because it plants the core issue early. Something agreed upon isn't being honored. And in courtroom battles, when agreements fall apart, things escalate quickly.
The MSA was prepared by the parties based on the agreements after conferring with counsel of the parties. And nobody, and I'm asking a question here, Mr. Canfield, did anybody ever discuss filing something with the court to amend or modify or correct the MSA?
No, not that I'm aware of.
And so I understand what before I award sanctions for willful and what's the word, commutacious disobeyance of a court order. Why is this provision about whatever surviving spouse benefits are available so important?
Well, if one, it's an order of the court. Two, then agree that my client would receive the time of the entry of the MSA and judgment, would receive that if Mr. Gibbs passed, that any surviving spouse benefits would be passed to my client. All I'm asking is conformance with the order.
Is that surviving spouse benefits as to his portion of the 401k as to the one that is paid to her as an alternate payee?
It says wife shall be awarded 50% of the value of husband's 401k, 50% of the marital portion of pension, and including any survival benefits as may be available. Wife is awarded that. That's what the order says.
Okay. So my question is, and I'm not going to say that hasn't been in orders I've signed before, but it seems like it doesn't really mean anything. What survival benefits are conveyed with a 401k?
Well,
because you're not doing anything but naming an alternate payee. And, I don't know how old Mr. Gibbs' wife was at the time of that, or will be at the time of that transfer. But unless she takes her payment and rolls it over into a rollover IRA, she's going to pay income taxes probably at 34%, depending on how big a piece it is. And if she's under age 59, I think it is, she's going to pay penalties.
so
Well,
that's not before the court. It's not before the court.
Well, wait a second.
No,
I'm not going to award sanctions if it's meaningless.
it is not meaningless.
Superfluous. Well, then just tell me what it means.
It means that if Mr. Gibbs passes, she is going to receive any death benefits that are awarded to a surviving spouse. That's what it means.
On a 401k?
On his pension.
Okay, so if he named her as the beneficiary to his 401k, does that mean he's not allowed to change her as the beneficiary?
That is correct, Judge.
May I, Judge?
Yeah.
I believe there was a separate quadro.
Judge, I can't hear what he says.
He's trying to explain. Speak up, okay?
There's a separate quadro for the 401k, and that was agreed and entered. And as far as I know, the 401k has already been divided.
Okay, what plan are we talking about?
Talking about the
Pension.
pension, Judge. And
Okay,
If I may,
so is he receiving his pension?
yes,
Okay. So, and is she the beneficiary? Are there surviving spouse benefits?
yes, he made the election prior to his awareness of the divorce being, that there needed to be a divorce.
Well, isn't he stuck then?
He is, however, the problem, Judge, is a matter of specificity. As you pointed out, it's not clear from the language that's in the MSA.
Well, wait a second. I was operating I was using a 401k as an example. If it's a pension with a surviving spouse option, and she said, I want to get the death benefit, I'm the beneficiary. If he dies before me.
Buckle up, guys, because what follows is a pattern that judges absolutely hate: delay after delay. The case keeps getting continued across multiple dates, and that repetition quietly builds frustration in the courtroom. Each postponement chips away at credibility, making it seem like someone is either stalling or avoiding resolution. The narrative here isn't explosive yet, but it's strategic. It shows how time itself becomes a weapon in legal disputes. By the end of this segment, you can already feel the judge's patience being tested.
Yes. The issue
That seems pretty important.
yes. The issue that we have is that the petitioner's share of the pension is one half of the marital share of the pension. And the surviving spouse is 2/3 of the entire pension, not the marital share of the pension.
If he dies.
Yes. The issue that we were not aware of until the most recent draft of the Quadro in communication with the pension fund is that if Mr. Gibbs, both parties are 57.
Just tell me what the folks at the pension fund tell you.
Well, the question we asked them was if he were to get remarried, what would happen to who is his current spouse when he passed away, based on the language that's in this Quadro.
Mm-hmm.
And what we were told was that this Quadro provides that the petitioner gets 60% of the total benefit, not the marital share, and if there's a new spouse, that person would get 0. That is our concern or issue that we would like to.
Well, I think that's probably a correct reading.
So what we're arguing is that
The petitioner would get the remaining 60%, because presumably she'll just continue to collect her portion even after his death.
I'm sorry, the surviving spouse benefit is 2/3 of the benefit.
Okay, so the 2/3 benefit, she would be, if he dies first,
Yes,
okay, she would receive, instead of whatever the marital share is now, you said 40%,
no, 6%.
6%?
Yes, Judge.
So she's getting 6% of his monthly allocation.
Correct.
If he dies, she gets the entire death benefit, or 60%,
67%.
67%, 2/3 of the. So if he's receiving $3,000 a month and he dies, she'll get $2,000 a month until she dies.
That's the way it's drafted, Judge. The issue that we have is that, I mean, our argument is that it should be 2/3 of the marital portion of, if he were to be remarried, his new spouse would.
But that isn't what the MSA says. The MSA says he gets all the death benefits, or she gets.
Well, that's our concern, that it's not clear.
It is clear. He just read it to me. Were you not listening?
There's a paragraph in the.
Read it to me. You must have it there in front of you.
This is the Quadros, not the MSA.
I want the MSA. I'll pull it up.
Oh, I've got it, Judge. I mean, it's the same paragraph Attorney Canfield read.
What paragraph is it in the MSA?
Page 5, Judge, number 6 under pensions.
Okay. Under pensions and retirement accounts. Okay, page. Assuming no monies have been withdrawn, wife shall be awarded 50% of the value of the husband's 401k and 50% of the marital portion of husband's pension, including any survival benefits as may be available. And that's parenthetical, by a quadro. And husband shall be awarded all of the remainder. So he get his 94% while he's alive, but it says including any survival benefits as may be available.
We were applying the prior phrase, that's 50% of the marital portion of any survival benefit.
All right, guys, now the tension starts to take shape as blame enters the conversation. One side claims they've done their part, drafting documents and waiting, while pointing fingers at the other for not cooperating. This is where the case shifts from procedural delays to direct conflict. The mention of refusal to even send documents to the plan administrator raises serious red flags. It suggests not just disagreement, but obstruction. In legal terms, that's dangerous territory, especially when court orders are already in place.
It doesn't say survival benefits.
Well,
It says, and 50% of the marital portion of husband's pension.
So she receives 19.675% of the marital during the marriage, while he's alive.
And Mr. Canfield, and I understand what Mr. Ainsworth is saying, is you have to read it in context. And she is getting 50% of the marital portion of the husband's pension.
Right.
And parenthetical, it could be read to say that including any survival benefits as may be available on that portion.
yes, Judge, that's exactly what we're saying. That
I understand what you're saying. Does that make, I mean, I'm not asking if you agree with it, but it just clicked for me, the argument he's trying to make. The use of parentheses, generally, makes it an afterthought such that, he would have to continue her as the beneficiary to the marital portion of the pension. But if he got remarried, if they'll let him change beneficiaries, and they, I assume they would,
Judge, that's exactly where the problem occurs.
as to the 94%.
The language that's in the quadro, I have a copy of it. If that's, with that.
Mhm.
May I hand it?
Well, what does it say? Just,
The paragraph that we're having an issue
I
with.
think Mr. Canfield attached it to his memo.
Okay. So on page 2, section 4, death of the participant, paragraph B, if the participant elected a form of benefit payment with a surviving spouse option and named the alternate payee as a survivor, under the terms of the plan, the participant is eligible to cancel the surviving spouse option upon divorce, then select one. The the box that's checked says the participant may not elect to cancel the surviving spouse option. Alternate pays benefit under the surviving spouse option will begin upon the participant's death. The reason that's a problem, Judge, is on the next page,
Uh-huh.
where under section 9, the limitations for the quadro, nothing contained in this order shall be construed or require the plan or plan administrator to, and paragraph C there is to pay any benefits to the alternate payee that are required to be paid to another alternate payee under.
Well, except that Mr. Canfield's argument is, this is easy. You check box 2.
Yes, Judge.
Right.
The
limitations are as against the plan administrator.
yes,
Right.
Judge.
So as long as the plan administrator follows the documents, Plan C doesn't have anything to do with the fact that the plan administrator, because the plan administrator is going to do whatever you tell it to do.
Yes, Judge. What I'm saying is we should be telling the plan administrator to distribute a marital portion of the survivor benefit. If Mr. Gibbs is not married.
Okay. Now, wait a sec. That is a form that was provided to the parties by the plan administrator.
Correct.
All right. Now, it only has 2 check boxes. So what you've provided for in this MSA, if it's read to she gets the whole death benefit and he can't change, this must be something they see with some degree of frequency.
All right, guys, this is where the argument sharpens into a direct accusation. The attorney makes it crystal clear. This was an agreed order, not a contested fight, and you don't just get to change your mind afterward. That statement carries serious weight because it challenges the very foundation of legal agreements. If parties could walk back terms whenever they wanted, the system would collapse. The insistence on enforcing the original order shows confidence, and also signals that sanctions might not just be a threat anymore.
Yes,
So, Judge, can I point out that paragraph C that he talks about says that benefits required to pay to another alternate P under an order previously determined. So we're not talking about a subsequent situation. There's no prior orders relating to the pension. So
Right.
paragraph C does not apply.
I'm talking about the situation where this quadro is the prior order.
Well, wait a second. What does that paragraph 9 subparagraph C have to do with anything?
It has to do with, in the event,
It protects the plan administrator.
yes,
Who cares? What you want is you want to write in a third option. You want to have a checkbox 3 that says, upon his death, his surviving X gets 6% of the death benefit. And as to the remaining 94% of that death benefit, we don't care who it goes to.
well, I mean, what we're actually, I mean, if he has another spouse, that person would be entitled to his portion.
Not unless he made her the beneficiary.
That's what I'm saying. If this quadro is entered, Alicia's the beneficiary, and that can't be modified. That's the
Right.
paragraph about.
Box 2.
Yes, Judge. If, I mean, it's a matter of,
How long were these 2 people married?
a little more than 4 years, Judge.
4?
Yes. My client worked at Chrysler for 30 years. So the fractional marital portion is 49 over 360, which is 13%. Where we're coming up with the 6% number for.
Judge, it's 9-point-something%. I don't know where it keeps saying 6.
Whatever it is, it's less than 10%.
Yes, Judge.
Well, why is he giving
No,
up half?
it's 19, I'm sorry, it's 19.675.
Okay,
Should be awarded one half.
right now, that's not my big concern. Why, is he getting, why is she getting half of his 401k?
The benefits of Chrysler have changed several times during my client's working there, and the 401k actually didn't begin.
Until they were married.
Correct.
So there's not much in the 401k.
Correct, Judge. We were never fighting over the 401k. In fact, one of the first settlement proposals my client gave was to turn over the entire 401k.
And is he paying maintenance?
No. This is not a maintenance case.
So she works.
Yes, Judge.
Does she have a 401k
I don't believe
or a
so.
pension?
I don't believe she had one previously. And what we're proposing, she would receive the entire 66% in the event my client is not married at the time of his death.
Yeah.
That's-
Well, they're both 57.
And potentially they could both live another 20 years. I mean,
Well, potentially they could both live another 20 years, but potentially neither one of them could ever remarry.
correct. Correct. I mean, I wasn't, this isn't something I've come across in my practice before, and recently.
Well, I would say from the drafting that I will tell you that I'm sure it exists. I would say that it's unusual for it to happen when there is not a longer marriage. I would say, and I'm just going to be that in context,
Buckle up, guys, because now the judge steps in and starts digging deeper, and this is where things get really interesting. The focus shifts to whether anyone even attempted to formally modify the agreement, and the answer is no. That's a critical misstep. Then comes the turning point. The judge questions whether the disputed provision even has real meaning. If it doesn't, sanctions might not apply. But if it does, someone could be in serious trouble. This moment flips the pressure back onto both sides.
it doesn't appear that the attorneys in drafting this document used boilerplate.
No.
And that the result is that I'm going to be honest with both counsel. I was not prepared to make a finding on whether this MSA is ambiguous this morning. But under the totality of the circumstances, where they were only married for 4+ years, where it's got that parenthetical reference to death benefits, I mean, I think there's clearly a question as to whether this was, maybe, maybe it clearly was her intent. Maybe Mr. Canfield and his client knew damn well what they were doing. Maybe it, as you said, went by you without question in the drafting because it wasn't something you'd encountered before. I don't really know, but it's starting to sound that there clearly was not a meeting of the minds on this provision of the MSA.
Not true, Judge.
Judge,
Okay, hold on. Mr. Canfield, why is that not true?
Because the order was entered with both parties present, both parties signed it, both parties reviewed it with their attorneys. So when you now,
I entered it. I entered it, and I'm sitting here today looking at it, telling you, I don't know what it means.
All right, so are you telling me every single time we have to present you with a marital settlement agreement?
Mr. Canfield,
Detail.
Mr. Canfield,
Then explain to me why the court, when it enters an order, now comes back and says, well, wait a minute, I didn't understand that order.
Mr. Canfield, you are on the verge of contempt. You are maligning the court. And
I'm
the
not,
fact
Judge.
of the matter is, I'm trying to be as diplomatic as possible in saying that the court, one, has there is nothing on the court that requires it to go through a marital settlement agreement sentence by sentence to make sure that the attorneys did a good job. All right?
I agree.
Or to question the parties as to what was intended by the parties.
I agree.
For me to say to you today, I don't understand what this provision means, is not my fault. It's yours. It's yours. And I will tell you that in the context of this marital settlement agreement, with a 4-year marriage, with neither party going in, having an understanding of what the death benefits available were, or even making inquiry as to the nature of the death benefits or what they meant, slapping a parenthetical clause into a quadro agreement is hardly clear intent. So, you, Mr. Canfield, have the benefit of a lot of times in front of this court, in front of all of the courts in this circuit, and experience and knowledge. But this time, you need to calm down.
All right, guys, now we hit the heart of the confusion, and it's all about interpretation. The discussion dives into what surviving spouse benefits actually mean, especially in the context of a 401k versus a pension. The judge isn't just listening, he's challenging, probing, forcing clarity. And when the idea that a beneficiary might be locked in comes up, the stakes jump instantly. This isn't just technical language anymore. It's about control over future financial benefits. You can feel the room tightening as the implications unfold.
I'm going to ask, what, if anything, either of the parties would like to do now that you find yourselves in this fix. Because I'm certainly, after what I've heard today, not going to award sanctions.
At least enter the quadro order.
Why would I do that?
Why wouldn't you?
Because that gives you what you want.
Yes, because we believe we're
I
right.
don't want it.
I understand, but I don't believe, based upon the marital settlement agreement, that he has a right to come back and redo the agreement.
I
30
think
days,
you're
the
wrong.
final and appealable order.
Okay.
Not order.
I am not going to order that quadro.
And if you're going to deny my motion, then we'll go forward with whatever we need to do.
Okay. Well, I'm asking you, what do you think that is?
I don't know. You're the court. You tell me.
Well, Mr. Canfield, it sounds to me like it's going to take some parole evidence to figure out what both of the parties knew, wanted, or anything, or if you tell me that you don't have anything else to offer other than what you offered today, I'll just reform it today.
I do not understand what the court means.
That I don't know any other way to put it. I'll blue pencil the son of a bitch today if you don't want to produce anything else in terms
What do you mean blue pencil?
I'll change the terms of the MSA.
You cannot, Judge. It's more than 30 days have gone by.
Okay, well then I'll just refuse to enter the quadro. Unless the parties can come to an agreement as to what the quadro should say.
If you make a final and appealable order, then we will proceed as required.
So you would put the burden on Mr. Ainsworth to file the appeal.
Yes. I think the MSA is clear that my client is awarded such survival benefits as may be available. We didn't hide that information. It is in plain text.
It is not. It is not. That's where we disagree.
Well, I don't know how else to put it into plain text except by doing what I did.
Well, you don't put it in parentheses for one thing.
No, because I wanted to be clear that that was
You could
included.
say something to the effect of, except to the extent of death benefits, which are 100% available to the ex, instead of saying, including any death benefits that come with her 50% or marital share.
That's not what it says.
It is what it says.
Well, maybe I'm reading it wrong, but I'm saying including any survival benefits as may be available.
As to what? Marital share or the whole thing?
There's no limitation placed on that, Your Honor.
Why is it in parentheses then? The parentheses themselves are a limitation. It's an afterthought.
Not an afterthought. It's part of the agreement. The plain language. I don't understand the issue.
It is, I find that the provision of the division of the pension benefits of the petitioner in the marital settlement agreement are ambiguous. And I deny your order for entry of an order, a quadro, and for sanctions.
Thank you.
Okay.
Unappealable?
I want it, sure.
Okay.
Reason.
Buckle up, guys, because this is where the case explodes into real financial consequences. The pension fund's interpretation reveals that one party could receive a massive portion, potentially cutting out any future spouse entirely. That's not a small detail. That's life-altering. The judge even acknowledges that this reading might be correct, which shifts momentum dramatically. Now the argument isn't just about wording, it's about fairness, intent, and who truly benefits. At this point, the tension peaks because the outcome could reshape everything.